You're listening to the North Star Law Firm podcast. Clear, practical analysis of tax and bankruptcy matters that affect business owners and individuals. Each episode breaks down a current legal development and explains what it actually means for the people who have to deal with it. Brought to you by North Star Law Firm in Houston, Texas. Here's today's topic.
Imagine you co-own a business. You and your partner, you've built this company up for years. You know, the clients, the operations, just the whole rhythm of the work.
Right, you're a team.
Exactly. And then, suddenly, your partner dies.
Oh, man.
Yeah, the grief is immediate, but so is the professional crisis. Because your partner shares in that company, they don't just, evaporate. They go to their family.
Which is, a nightmare scenario for a closely held business.
It really is. Overnight, you are in business with, say, a grieving widow who has never worked a single day in your industry. Or, out-of-state kids who have absolutely zero interest in the company and might just want to, sell their half to your biggest competitor.
Yeah, and the surviving owner desperately needs to maintain operational control. And frankly, the grieving family rarely wants an active job in a company they just don't understand.
Right.
What they usually want and what they desperately need right then is cash.
And most of you listening, you probably already know how to solve this. You sign a buy-sell agreement.
Standard operating procedure.
Exactly. It contractually dictates that if one owner dies, the survivor buys out the deceased's family at a fair, predetermined price. The family gets the cash, you get the control.
Simple enough on paper.
Right. But today's deep dive is built on some recent legal analysis and the books Taxed and Trusted by Houston-based attorney and CPA Philip Zagati. And, okay, let's unpack this, because our mission today is to explore one tiny, seemingly boring administrative detail in that standard paperwork.
A detail that recently blew up a multi-million-dollar estate at the United States Supreme Court.
Yeah. Because, look, writing the agreement is easy, but finding the money is hard.
That is the whole problem right there.
Oh.
If your partner's half the business is worth, say, $3 million, somebody has to physically write a check for $3 million to their family.
Which nobody has.
Exactly. A typical mid-sized business does not keep that kind of cash sitting idle in a checking account. And the surviving owner rarely has that much personal liquidity just, lying around.
So, the industry relies on a really standard, elegant solution, which is life insurance. You buy a policy, someone dies, the death benefit pays for the shares.
Boom, problem solved.
You'd think. You buy the insurance, you file the paperwork in a cabinet, and you go back to running your company. But there is a vital, seemingly mundane question that most owners just let their insurance agent handle.
And they never give it a second thought.
Never. And the question is simply this: who should actually own the policy?
Right, and it sounds like a pure technicality. You generally have two choices. Option one, the company itself owns the policies on the owner's lives, collects the cash, and buys the shares back directly. Option two, the individual owners own policies on each other personally.
And looking at the mechanics, the end result looks entirely identical. The insurance company writes a check, the family gets paid the exact same amount of money, and the surviving owner ends up with full control of the business.
Right, the outcome feels the same.
But that exact choice, whose name is typed on the owner line of that insurance policy, is a massive hidden trap. And it's a trap that just blindsided some very smart legal professionals.
Yeah, to really understand this trap, we have to look at a real family, Michael and Thomas Connelly.
Okay.
They were brothers who co-owned a building supply company in Missouri. Michael was the majority owner. Thomas held the smaller minority share. And by all accounts, they were, the model of responsible business planning. They did not leave things to chance.
Right. They sat down years ago. They signed a proper formal buy-sell agreement. It dictated that if one brother died, the survivor had the first right to buy those shares.
And if the surviving brother declined to buy them personally, the company itself was contractually obligated to step in and buy the shares back.
And to make sure the company could actually afford to do that, they funded the whole thing flawlessly. The company purchased life insurance on both brothers, $3.5 million of coverage on each of them. And the company owned the policies, the company paid the premiums out of its own accounts, and the company was the designated beneficiary.
So Michael passes away.
Tragic.
Yeah. And Thomas, looking at his own personal finances, he declines to buy Michael's shares out of his personal pocket.
Which triggers the backup provision.
Exactly. The company steps in, collects the life insurance money, and uses $3 million of that tax-free cash to purchase Michael's shares directly from his estate.
Okay, here's where it gets really interesting. Because everything operated perfectly, the plan did its job. Michael's family got their $3 million, and Thomas, as the only remaining shareholder, he now owned the entire building supply company.
The family was protected, the business was secure.
And the IRS sent a bill.
Oh, yeah.
And we are not talking about a small administrative adjustment here. This was a massive tax bill aimed directly at Michael's estate.
Which brings us to the valuation problem. That's the heart of this deep dive. When a business owner dies, their estate owes tax based on the total value of their property on the exact day they died.
Right.
Because Michael owned a large majority stake in this closely held company, the central question for the IRS was entirely focused on, well, the value. How much was that building supply company actually worth on the day Michael Connelly died?
And the estate's position here, I mean, it sounds so completely logical that I would have argued it myself.
Oh, absolutely.
The estate essentially told the IRS that the $3 million in insurance proceeds should not count toward the company's total wealth. Yes, the company received the cash, but the company was legally, contractually obligated to hand that exact $3 million straight over to the family to buy those shares.
They viewed it as a wash.
Exactly. It's just pass-through money. Look, it's like an escrow account. The money comes in one door and immediately goes out the other to satisfy a pre-existing debt.
Yeah, that makes sense intuitively.
If I'm holding $1 million in a briefcase, but I am legally contracted to hand that briefcase to you in 5 minutes, I am not a millionaire. I am just a delivery mechanism. The estate argued you cannot possibly count that cash as company wealth. And frankly, that feels incredibly right.
It does. But what's fascinating here is the IRS deconstructed that logic entirely.
Really?
Yeah. They looked at the same briefcase, to use your analogy, and said, well, you are fundamentally misunderstanding what it means for a company to buy back its own stock.
How so?
The IRS argued that on the day Michael died, the company undeniably owned an asset worth $3 million, the insurance payout. That meant the company was $3 million richer at that exact moment before the shares were ever actually purchased.
But wait, the obligation still exists. The company had a binding contract to spend that money. How can the IRS just ignore the liability side of the ledger?
Because paying out money to buy back shares is not a liability or a debt in the traditional corporate finance sense.
It's not.
No. The IRS argued that when a company buys back its own shares at fair market value, the company does not actually lose value. It simply trades one asset for another. It gives up cash, but it receives shares in return. It is a value-neutral exchange.
Wow. So buying your own stock isn't an expense, it's just an asset swap.
Correct. Therefore, the company was indeed $3 million wealthier on the date of death, and Michael's estate taxes needed to reflect his majority share of that newly inflated company value.
That is, wow. So the estate is fighting this, standing on common sense, and the IRS is standing on rigid structural corporate finance theory. And this dispute goes all the way to the top of the judicial system.
Right up to the top. In 2024, the United States Supreme Court handed down its ruling, and the decision was unanimous. Every single justice sided with the IRS.
Wait, unanimous? Like, really? That means even justices with completely different judicial philosophies looked at this corporate structure and agreed it was fundamentally flawed.
Every single one of them.
That is terrifying for anyone who thought they were operating in a safe, gray area of the tax code.
It should be a wake-up call.
Yeah.
The court's reasoning anchored on one clean idea, stripping away all the noise about briefcases and escrow. They affirmed that buying back shares at fair value simply does not make a company poorer.
Okay, break that down for me.
Think about Thomas, the surviving brother. Before the company brought back the shares, Thomas owned a smaller percentage of a company that had an extra $3 million of cash sitting in it.
Right.
After the company bought back the shares, that cash was gone, but Michael's ownership stake was also gone. So Thomas now owned a much larger percentage of the remaining company. Economically, Thomas was not worse off, and the company, as an entity, was not worse off.
It simply swapped the cash for the shares.
Precisely. And because the company's total value didn't drop when it fulfilled that contract, that insurance money absolutely had to be included in the company's total valuation on the day Michael died.
You know, the irony here is physically painful. The insurance was purchased for one specific noble reason, to create a safety net for Michael's family. But because of how they structured the ownership of the policy, the very existence of that safety net artificially inflated the value of the company, which in turn inflated the value of the shares the family was selling.
It's a brutal outcome.
It really is. It was Michael's estate that ended up paying roughly $900,000 in additional taxes. Almost $1 million just evaporated purely because the company's name was on the policy.
It is a profound penalty for a family that was actively trying to do the right thing. I mean, they were penalized for their own responsible planning because they used a structure that the tax code ultimately punishes in this specific context.
Okay, so what does this all mean? How does a listener actually avoid this trap? If a business owner is driving to work right now and realizing, oh no, my company owns our life insurance policies, what is the fix?
The direct takeaway from the Supreme Court's logic is this: don't let the company own the life insurance policy if you can avoid it. The structure the Connelly brothers used, where the company owns the policy and buys the shares, that's called an entity purchase or a redemption agreement. That is exactly the structure the Supreme Court just penalized. The alternative is called a cross-purchase agreement.
Cross-purchase. Got it.
Yeah. In a cross-purchase, the business owners hold the life insurance policies on each other personally.
Walk me through the mechanics of that. Like, how does moving the policy out of the company change the tax outcome?
Well, if you and I have a cross-purchase agreement and I die, the insurance company pays the death benefit directly to you, the surviving partner.
Okay.
The money goes into your personal bank account. It never touches the company's ledger. You then take your personal funds and buy the shares directly from my family.
So the company is completely bypassed.
Entirely bypassed. The company never receives a dime of insurance proceeds, which means there is no sudden influx of cash inflating the company's value on the date of death.
That makes total sense.
Right. You achieve the exact same protection for the family. The survivor gets the shares, but the company's valuation remains flat. It is a radically different and much safer tax result regarding the estate tax trap we just discussed.
Let's stress test this in the real world, though. Because with two owners, a cross-purchase is easy. I own a policy on you, you own a policy on me, 2 policies total.
Sure.
But wait, what if you have a business with 4 owners? Or 6 owners? If everyone has to own a personal policy on everyone else, that turns into an absolute administrative nightmare. Owner A needs policies on B, C, D, E, and F. Owner B needs them on A, C, D. You know what I mean?
It's a web.
Exactly.
Yeah.
You are suddenly managing dozens of individual life insurance policies just to keep one business afloat.
You are identifying the exact scalability issue that makes business planning so challenging. A cross-purchase agreement gets incredibly messy very fast as you add more partners. I want to be clear, it is not a universal magic shield that solves every problem effortlessly.
So what do they do?
Well, there are workarounds. Sometimes advisors will set up a separate, small entity, like a dedicated LLC, whose sole purpose is to hold the life insurance policies on behalf of all the owners.
Oh, clever.
Yeah, it can achieve the tax benefits of a cross-purchase without the chaotic tangle of 30 different policies. But designing that LLC requires serious, sophisticated coordination between a tax attorney and an insurance professional.
Which means listeners might be tempted to take shortcuts. If you are listening to this, you might be thinking, well, I'll just check my agreement, and if the company owns the policy, I'll fix it myself.
Do not do that.
Right. Because we have 2 massive warnings from Philip Sagotti's research about trying to fix this without specialized counsel.
The first warning involves the price written in your agreement. Many business owners have a buy-sell agreement they signed, 15 years ago. Maybe they just wrote in a flat number or a simple handshake formula and haven't updated it since.
And that's a problem.
A huge problem. You cannot assume that just because you have a price written on a signed piece of paper, the IRS will automatically respect it.
Because they assume you're just making up an artificially low number to avoid estate taxes.
That is exactly their assumption. The rules that govern when the IRS respects a price in an agreement are strict. The buyout price must reflect a real arm's-length business deal.
Right.
It cannot be a suspiciously friendly family bargain designed to quietly pass wealth to the next generation tax-free. It has to look like a price that unrelated parties would have genuinely negotiated.
Got it.
If your agreement uses a stale price or fails that test of being a real business arrangement, the IRS will completely ignore your contract. They will value the business using their own standard rules, which leads you right back into an inflated company valuation.
Okay, so a dusty old agreement is dangerous. But the second warning is even more urgent. Please, whatever you do, do not pause this deep dive. Call your insurance agent and tell them to immediately move your existing policies out of the company's name and hand them to the partners personally.
Yes, please do not do that.
Doing that is like trying to fix a leaky pipe by ripping it out of the wall and flooding your whole house.
That is exactly what it's like. The tax implication of moving an existing policy is incredibly severe. This involves a mechanism called the transfer for value rule.
Okay, what is that?
The IRS created this rule to stop life insurance from becoming a speculative commodity. They do not want investors buying and trading policies on strangers' lives for profit.
Makes sense.
Generally, the greatest benefit of life insurance is that the death benefit is received completely tax-free. But if you take an existing policy and transfer the ownership of it for any kind of value, you trip that anti-speculation wire.
So transferring an existing policy, it's like trying to change the license plates on a moving car. If you don't do it with absolute precision, using specific tax code exemptions, the IRS assumes the vehicle was stolen and they tax the entire value of the car.
That is an excellent way to conceptualize it. When you move a policy between business partners to fix a buy-sell agreement, you can accidentally trigger that transfer for value rule. And if you violate it, you strip away the policy's tax-free status entirely.
Oh, wow.
Yeah. Suddenly, when the death benefit eventually pays out, the IRS treats that multi-million-dollar payout as ordinary taxable income.
Which completely defeats the purpose of the planning. I mean, you are trying to save the estate a few $100,000 in estate taxes, and you accidentally turn $3 million of tax-free insurance money into ordinary taxable income for the surviving partner.
Exactly. You cure the estate tax illness, but you create an income tax disease that is exponentially worse.
Wild.
Restructuring a buy-sell agreement and moving existing policies is absolutely not a DIY fix. It requires careful, professional navigation of the tax code to ensure you qualify for specific exemptions and don't trigger these unintended consequences.
And for our listeners specifically in the Houston area, or really anywhere in Texas, there is another massive layer to this that we need to address. This involves community property.
Right. If we connect this to the bigger picture, Texas community property laws add a significant and frequently ignored wrinkle to business succession planning.
How so?
Because of these laws, a married business owner's spouse might have a legal vested community interest in the ownership stake of the business itself. Depending on how the business was funded and when it was started, the spouse might also have a community interest in the life insurance policies used to fund the buyout.
Meaning this is not just a private gentleman's agreement between you and your business partner in a boardroom. There is a third party at the table who has actual legal rights to those assets.
The danger here is staggering.
Right.
If you redesign your buy-sell agreement or try to shift from an entity purchase to a cross-purchase, you cannot ignore those spousal rights.
Right.
If a spouse has not formally consented to the terms of the buy-sell agreement, usually through a spousal consent form, the entire agreement can be paralyzed.
Oh, man.
Imagine the surviving partner trying to execute the buyout, only for the deceased partner's widow to hire a litigator. The widow's lawyer argues that the agreement's price is unfairly low, and because the widow never signed away her community property rights, she is not bound by the contract.
So suddenly you are in court fighting over fair market value, the business is frozen, and the exact crisis the agreement was meant to prevent is happening anyway.
Exactly. Failing to account for community property introduces a level of fragility that can unwind the entire succession plan. It has to be managed proactively with legal counsel who understands both corporate tax structure and state family law.
We have covered heavy consequences today. I mean, a unanimous Supreme Court decision, massive unexpected estate taxes, the transfer for value trap, and Texas community property risks.
It's a lot.
It is. So let's bring this down to a concrete action step. Here's what you need to do. Go find your buy-sell agreement. It's probably sitting in a filing cabinet or buried in a digital folder somewhere, and there's a very good chance you have not looked at it since the day you signed it.
Very true.
Pull it out and look for two specific things. First, when an owner dies, who is legally required to buy the shares? Is it the company or is it the surviving owners? Second, look at your life insurance policies. Whose name is actually typed on the document as the owner of the policy? Is it the company or the individuals?
And if the answer to both of those questions is the company, you are currently sitting in the exact fact pattern that caught the Connelly brothers.
Right.
It doesn't mean your business is doomed, and it doesn't mean a cross-purchase is automatically the perfect solution for you. But it means you have a very serious question that you need to ask your advisory team. You need a professional to look at your specific documents and assess your exposure to this new Supreme Court precedent?
And the time to ask that question is right now. You want to ask it on a random Tuesday while everyone is healthy, the business is good, and nobody is grieving. You do not want to discover this valuation trap in the chaotic weeks after a partner passes away, when the agreement is firing automatically, the insurance company is cutting a check, and the tax consequences are locking into place before you even have a moment to breathe.
And I want to reiterate that the technical analysis for our discussion today was provided by North Star Law Firm in Houston, Texas.
You know, the Connelly brothers did exactly what they were told was right at the time. They were responsible, they planned ahead, they bought the insurance to protect their families. But legal interpretations shift. And what was once considered a safe, standard practice became a nearly $1 million trap.
Yeah, it really makes you think.
It does. It makes you wonder what other set-it-and-forget-it legal documents are sitting in your filing cabinet right now, silently turning into tax time bombs simply because the world changed while you weren't looking.
Thanks for listening to the North Star Law Firm podcast. This podcast is produced for general educational and informational purposes only and should not be construed as tax, legal, financial, or accounting advice for any specific situation. Listening to this podcast does not create an attorney-client or CPA-client relationship with North Star Law Firm. Tax and legal outcomes depend on the specific facts of each matter and on applicable state and federal law, which varies by jurisdiction. If you have a matter that requires professional advice, consult a qualified attorney or CPA licensed in your jurisdiction. For further inquiries or to start a conversation, visit us at htx-legal.net. Copyright 2026 North Star Law Firm. All rights reserved.